Ladies and gentlemen, how are you? Good to be back. Good to see you all out there. We're back for this Thursday night. It's Thursday night in Australia. Today was the very last day for closing statements in the Erin Patterson trial. Today is day 35 of week number 8. It is good to see you all. Great to be back. Um, we're not expecting much more to happen any for the rest of this week. Most likely, we'll be back early next week. Early next week, so a bit of a long weekend for court reporters and people working on the trial, and that's where we're at, guys. Hold on a second. Sorry, my cat's being naughty. He always wants to play up when we get on the live show. But yeah, week 8, day 35, the end of the closing statements. Prosecution closed a couple of days ago. This one here, this is the defense, Colin Mandy, SC, and it is his final few hours of his closing statement. And that's it. That's it, everyone. Next week, we'll get the judge's charge to the jury, and then it goes into deliberations. Nothing more than that. It's mostly up to the jury now. The judge will give his directions, or what we call down here a charge, to the jury, and we're done. A few more shows left. It'll be probably one for the one or two for the judge's charge, depending. I don't know how long he's going to go. However long that might be, and then we'll have a bit of a gap. We'll have a gap while the jury is deliberating. We're not expecting to have any access or anything like that between when they go into deliberations and when we get a verdict. Most likely, the next time you'll hear from me after the charge is read to the jury and they're put into deliberation and sequestered, will be a verdict in this case. That'll be it. So we really are at the pointy end of this trial now. It is business time. It is it is right at the end. We are right at the end after 8 weeks. What'll probably be 9 or more weeks by the time we get to a verdict. 9 or more weeks. We may even make it to week 10, but we'll see. It's up to what the jury wants to do. Aussie Tad, good to see you. Thank you so much. I saw this before I came on. A $80 super chat. Thank you so much. Towards your public transport and play lunch fund. Thank you so much. The support has been amazing. It really has. Thank you to everyone. Jay says gifted 1 membership. Thank you very much, buddy. And I gifted 5 out there to the chat as well. And Sean did one as well, saying nice work, Aussie Tad. Thank you to all of you. I appreciate it. Hey, old one. Hey, I saw you in the other night when when ShareBear gave away all those memberships to people. Hey, good to see you. High five. Good to see you. High five. We all liked your name. We all liked your name the other day. We're like, that's a great name. Although we felt like you were aging yourself, and we're like, is that what they're trying to do? Yeah, great to see you all. Great to see you. Hey, just another human. Laura T's here. Sean, Francesca is here. Who else is here? My friend Wendy R. Apparently, I'm here as well. Who else is here in our chat? Video Reel made it. Jay was here. Chipmunk was here. Who else? Aussie Tad again. Thank you so much. That is amazing, by the way. Gayla was here. Marjorie. I don't know if I've missed anyone. I hope I haven't. Hey, good to see you all. I know it's a bit of a funny time tonight, but hey, sometimes it just has to be at this time of night. Due to logistics and other things, it just has to be. Okay. So, you all know where we're up to now. You all know where we stand in the trial, right? We all know. I've given you the rundown and what a typical trial would do. So, let's read a little bit about what Colin Mandy said to the jury today. in his closing statement. Okay. All right. All right. So Colin Mandy said in his topics today, he went through a few different topics, but before I take you to the end of this, I want to read you this particular part of his closing statement. And I'm going to read it to you. It says, and again, Colin Mandy, SC, representing Erin Patterson. Now, the next topic, members of the jury, is the reluctance to have the children medically examined by what? Where is it? Medically okay. Is the reluctance to have the children medically examined by Erin. You will understand that this is a limb of the prosecution's case. The Crown says that she was reluctant, and they do so to try and demonstrate that she did not, in fact, serve them leftovers from the lunch. So, critical to that part of their theory is the evidence of Nurse Kylie Ashton. And this was raised as a topic at the hospital at 8:05 a.m. And he says, I have addressed you about that, the jury. He says, as you know from our examination of the evidence of Doctors Webster and Foote yesterday, that was plainly wrong, and that was not raised with Nurse Ashton at the first visit to the hospital. And so there goes the prosecution argument about hours of delay. There's not hours of delay. Erin, of course, arranged for the children to be brought to the hospital, as you know, and those arrangements were made in the very same conversation where the leftovers were first raised with Dr. Foote. That's for Dr. Veronica Foote, by the way. Dr. Foote told you that Erin accepted her advice about this, and once Erin understood the concerns, she made those arrangements with Simon, and the timing of those arrangements is confirmed by the telephone records, which was shown to the jury, and that's all consistent with Erin's account. And he says, on to the next part of his closing statement. Would the children have become ill from eating the meat with the mushroom scraped off? Guys, 1 second. Sorry, guys. My orange cat is being a jerk, trying to attack his sister. So they say, next topic, would the children have become ill from eating the meat with the mushroom scraped off? He says, it is a question, an issue. We say that that issue can only be addressed and only answered by an expert. Colin Mandy says, Dr. Rogers made this argument to you. These leftovers included a small piece of meat which tested positive for the presence of beta aminidin, and that is an exhibit in this case in the table of toxicology results. The prosecution then said, in other words, the amatoxins penetrated or remained on the cooked meat. Colomandi continues and says, no expert evidence, no expert witness gave that evidence, and we submit to you that's another invitation to speculation, to make an assumption rather than acting on the evidence, whether meat can absorb amatoxins, how and to what extent. Those are the questions that require expert scientific evidence. Colomandi says, she went on to say, and he's quoting the prosecution here, however, the scientific evidence in this case strongly suggests that simply scraping off the mushroom paste would not have been enough to prevent the children from ingesting amatoxins. Collins says our submission to the jury is that this is misleading impression of the evidence. He says absolutely no expert witness gave evidence of that. You can't rule out other possibilities, including that amatoxins were not absorbed into the meat at all. For instance, and he says, but you know that he says, But you know this is a piece of evidence. Amatoxin molecules are very thermodynamically stable, and this is evidence from Dr. Gerastamalos. Does that mean they're more or less easily absorbed into meat? And then he says, Dr. Rogers continued in this quote, the meat sample was simply unable to be separated from the poisonous mushroom paste, and that is why the specimen tested for beta aminidin. Maybe the toxin penetrated the meat, or maybe the mushroom paste just could not be separated, so the sample tested positive for beta aminidin. And Collins says, and that whole argument depends on evidence that the person doing the testing was trying but failing to separate the tiny pieces of mushroom from the meat, and that person, the person doing the testing, did not give evidence before the jury. There is no evidence. He said that's what they would. There is no evidence that that's what they were trying to do. No evidence that tiny amounts of toxin discovered in the ethanol in the test tubes would have had any effect on anyone. Absolutely no evidence. Absolutely no evidence about it, despite the prosecution knowing for 2 years that that's what the accused said she did. And in those vials that were tested with the ethanol samples, some were positive and some were negative. Does that not show that the distribution of amatoxin is very inconsistent in those samples? He says, we also know that by the time the leftovers were in the bin, they were seeping with liquid. Adrian Villalobos had to double bag them in order to stop the juices from leaking out. Did that have something to do with whether and how the amatoxin found its way into that vial that contained the meat sample, if it was really in the meat at all? Again, the prosecution is speculating, and we say constructing arguments which don't have any basis in evidence. And you have to be extremely careful about that in our submission to the jury. Just because an argument is confidently expressed doesn't mean that it's correct or that it's based in the actual evidence. And when the prosecution makes arguments to a jury in a criminal trial, they should always be based completely and fairly on the evidence, as you would appreciate. They have a duty to be fair. They're the ones who bring the charges, they bring the allegations, and they're the ones who have to prove them beyond a reasonable doubt. That question could only be resolved by expert evidence, and there isn't any. So that's his comments on the amatoxin in his closing statement. Hey Elaine, good to see you. Hey Julie Miller. Hey Zen, good to see you guys. Good to have you here. Hey Permaculture. Hey Just Another Human. Alex, hey Alex McDonald, I saw you on Twitter. I saw you follow my account on Twitter. Good to see you, mate. No, that'll probably happen sometime next week. Sometime next week. There is no court tomorrow. We're not heading in for tomorrow. We've got a bit of a long weekend. So no, what you're describing will probably happen sometime next week. So not tomorrow. We've still got a judge's charge to the jury to go, and it'll probably happen after that when the jury is sent away to deliberate. Once everything is like sort of done, and then the jury is supposed to go get to a verdict, or maybe they can't. But during that process between the judge's charge and when the jury deliberates is when I would expect that to happen. Guys, hold on. My cat is being a jerk. Hold on. Sorry about that. I don't know why he's being a jerk tonight. Every time I turn on the camera, he acts like this. Every time he's like, "Oh, Dad's doing something that I don't want him to do. I want him to play with me." All right. So we spoke about the aminidin and the evidence about the the toxin being in the meat, and that's what Colin Mandy had to say to the jury in his closing statement on that subject. Okay. All right. All right. So they say he says he wants to turn to a different topic. And he says it's about the ambulance journey to Monash Hospital in Melbourne. And he says Miss Spencer said that Erin was calm and chatty, and that's from the driver of the ambulance, as you know, not from the ambulance officer who was in the back. Erin was hooked up to fluids by that time. She'd had plenty of fluids, and he says, I think from the hospital, and that she'd had a dose of fentanyl, and no one else who engaged with Erin previously at the hospital said that she was calm and chatty. Everyone who dealt with her said she was anxious and teary, and that's exactly how Erin told you that she was feeling. And he says he wants to move on to a next topic about Erin actually being sick. And he says Erin was actually sick, an important part of the prosecution case. Her diarrhea had not subsided without medical intervention, and that's why she went to the hospital in the first place. She was on a drip, as you know. She had ondansetron, she had potassium. She was plainly not as sick as the other lunch guests, nor did she ever represent that she was. She was getting better by the time she was discharged, and what Dr. Rogers said to you was that the reason for every sign and symptom that was observed by medical practitioners, the blood tests, Dr. Burston's report, was explained by stress. Stress because of panic, stress because this brilliant, careful plan of hers was all coming unstuck, and our submission to you, that's an unfair way of categorizing the evidence because it undermines the evidence of their own witness, Professor Burston. Colin Mandy continues and says, I am sure you will remember him. He's an intensive care specialist with 35 years of experience. He said this in his evidence. The elevated fibrinogen is consistent with an acute illness, and that's a question. The elevated fibrinogen is consistent with an acute illness, is it? And his answer was, you would see that in an acute illness. You might see it with stress. And then at the time, His Honor asked, what do you mean by acute illness? And Dr. Bernstein replied, well, typically, if you had a surgical stress, so you had an operation, you might have a knee replacement. I'd expect fibrinogen to be elevated, so something that caused stress to your body in that respect, and that would be a classic surgical procedure where you would see that and where you would see that elevated fibrinogen. We don't measure it routinely, but that would be the sort of thing that might do it. And they are quoting him again in his previous evidence. It says here, and this is Colomandy asking him questions. This is me asking questions. So Colomandy saying this is me asking these questions in cross examination earlier in the trial. And he says, some of them taken in isolation might be, for instance, oh, they're asking him here. We don't, yeah, they ask him, fibrinogen might be elevated because, for the instance, stress, correct? And the doctor says yes. And a diarrheal illness, that's physical stress, correct? The doctor says correct. And a diarrheal illness is a physical stress to the body. The doctor replied back then in his evidence, yes, that could cause it. It is a possible cause. And Colin continues here. That's what Professor Bernstein said. Stress can include physical stress like you get in a surgery or like you get with diarrhea, not simply panic. Okay. Yeah, I'm just going to go to the next bit. All right, he says here, his conclusions are a summary of his conclusions are expressed at the bottom of a document that was shown to us. He says, yeah, sorry, he says, Dr. Yeah, Dr. Bernstein, Professor Bernstein made about these things, for instance, a question that was asked to him: where's the evidence that if you are exposed to a small amount of amatoxin, that you would still have an impact on your kidney or liver? He said, where's the evidence of that in this trial? Where's the evidence about what level of exposure is required to have an impact on your liver or kidney? Where's the evidence of that from one of the many, many, several doctors, experts, highly qualified people who might have been expected to consider that point? They want you to draw a conclusion on the basis of this evidence, and we say it is a scientific conclusion, and they don't ask any expert about it. Collins says, our argument to you is that something was going on in Erin's body. Medical testing revealed three different factors, three things that can't be faked, three things that are not based on self report. Low potassium, that was the curve. And he says elevated hemoglobin, elevated fibrinogen. And he says, in Professor Bernstein's evidence, he was asked about this evidence. And they asked him here, what is your opinion about whether there is evidence or supports of Erin Patterson becoming ill from a diarrheal illness on the 30th of July? And the professor's answer is, I thought there was evidence that she had a diarrheal illness. We had reports of diarrhea, and despite the urea creatinine ratio not being elevated, I would give preference to the elevated hemoglobin, that she was somewhat dehydrated, and therefore I thought it was consistent with a diarrheal illness, a mid-level of dehydration at her presentation. And he says, Colomendi says, I put questions to him in cross-examination, and the question was, uh, the combination of things, the pattern of potassium, and then he said the hemoglobin, which starts out high in the 150s. This is from the doctor, by the way. The hemoglobin, which starts out high in the 150s and 160s, then returns to the 130s by the time of discharge. The reports of diarrhea, the physical examination of various times, the ambulance Victoria fluid balance charts, the elevated fibrinogen, all of these things, a combination of those things is what leads you to the conclusion that the evidence supports Aaron Patterson becoming ill from a diarrheal illness and becoming somewhat dehydrated as a result. Sorry, that whole thing was from Colin Mandy. Sorry, I got confused. The answer here is taken all together. Yes, that would be my conclusion. And they said, uh, y- you summarized the basis for it. So that entire thing I read out, I'll read it again. And it said the pattern of potassium, the hemoglobin, which starts out high in the 150s and 160s, then returns to the 130s by the time of discharge, the reports of diarrhea, the physical examination at various times, the ambulance Victoria fluid balance charts, the elevated fibrinogen, all of those things, a combination of those things is what leads you to the conclusion that the evidence supports Erin Patterson becoming ill from the diarrheal illness and becoming somewhat dehydrated as a result. That entire thing is Colin Mandy asking the professor a question, and then the answer is from the professor. Taken all together, yes, that would be my conclusion. You've summarized the basis for it. And then Colin Mandy said, that's their expert. And he said, it went on in re-examination. Now, Dr. Rogers, in her address, referred you to the chart and to the urea creatinine ratio and said, that's not consistent with dehydration. But as I have just identified, Professor Bernstein said, well, I wouldn't give preference to that. I would give preference to the hemoglobin levels, and they didn't refer you to that evidence. Dr. Rogers went on to say, and I have dealt with this issue, but this is what she said. As Professor Bernstein told you, stress can do that as a result of blood adrenaline going up, and that is in relation to potassium. Given the accused's most frequent diarrhea, on her account, all occurred before presenting to the hospital and her potassium levels were normal, we suggest that these potassium results were not caused by frequent diarrhea, but were rather, again, most likely due to stress. And they say, so she is saying, well, stress is on the one hand, that was from Dr. Rogers, that part, to make it clear. And Colin says, so she is saying, well, stress is on the one hand, frequent diarrhea is on the other. Colin says that's inconsistent with her expert because a severe diarrheal illness, he says, take out the severe. A diarrheal illness is consistent with stress, can create stress on the body. And he says, like physical stress, you might find it strange that the prosecution never asked the professor that question. And Collins says another scientific conclusion that the Crown case is based on, how much amatoxin you consume, no matter how much amatoxin you consume, you will be seriously unwell. Colin asks, where's the evidence of that in this case? And he says, from any of the toxicologists, the liver specialists, the emergency doctors, clearly an important point. Why wasn't anyone asked that question? Colin says, Dr. Rogers said a mild level of dehydration is not, we suggest to you, consistent with the accused story of having extensive diarrhea up to 25 to 30 times over the past 2 days. Colin continues and says, now the prosecution can't answer or submit that it's not consistent with that unless they ask a witness about it. And they say, Professor Bernstein's in the witness box, and they say, Professor, if someone had diarrhea 25 to 30 times over the last 2 days, would that be consistent with these blood test results that we're looking at? Yes or no? Straightforward question. He's the expert, not asked. So Colin's saying this question is an easy question, straightforward question, but no one asked the professor that question. Sorry, I know it can be a bit hard to follow at times. And Colin says that the professor was not asked that question, and he quotes it as not asked. The prosecution goes to you and says, well, that's a conclusion you can draw, notwithstanding we haven't asked Professor Bernstein the question. Professor Bernstein wasn't relying on Erin Patterson's self-reports as was suggested to you. He was relying on medical reports written by medical personnel in their expert medical opinion. He was relying on people who make observations of others, not Erin Patterson herself. He'd never spoken to her. And for most of his opinion, the most important parts, he was relying on what's contained in the chart that they showed. And they're saying which is blood test results. He was relying on potassium levels, hemoglobin levels, fibrinogen levels, medical experts, because that is what they wanted him to do, to test Erin's claim to whether or not she actually had diarrheal illness. That was the whole point of his evidence. Is it consistent with a diarrheal illness or not? Colin continues and says he was called by the prosecution. He's their own witness, incredibly experienced. He gave an opinion which was very clear, and the Crown says, no, even though we lead it as part of our case, you should have serious reservations about that evidence of unfakeable blood results. You should reject Erin's evidence, they say to the jury, on the basis of questions that weren't put to their own experts. So there you go. We got through that section. It was a little bit choppy in the middle there. I'm sorry about that. My notes get a little up and down at times as much as I edit them. I'm sorry about that. Hey, Aaron, good to see you. Yeah, you made it just in time for the diarrhea. Yeah, that's all right. I think we've said diarrhea a million times in the last 8 weeks. I think we're all desensitized to the word now. It's good to see you all. How you doing out there? Are you keeping up? Are you keeping up with the show? Hold on, who is beeping me? Okay. All right. How's it going out there? You guys all keeping up with the closing statement? I hope you are. All right. So Colin wants to talk about a different topic, right? And it's about time spent in hospital. And Colin continues and says, I have already submitted to you, the jury, that there were a very large number of witnesses, about 20 or so, that spoke to Erin in the 24 hours that she was in hospital. And those are the ones that are on the witness list in this particular case. It doesn't include other medical staff, doctors, or nurses, and he says, you know that Simon Patterson was not sharing information with Erin about how unwell his parents and Ian and Heather were over this time. He told you that. You know that Erin also had the care of her children and that they had had some experiences in hospital which were regrettable. And he says, notwithstanding that the level of stress and scrutiny she was under, Erin was under, her core account to all those people that she spoke to was consistent across all four of the investigations. It would be remarkable, we say, if all of those people gave exactly the same account of the conversations with Erin. Imagine that. If they all agreed exactly that she used the same words and said the same exact same things, it would be firstly totally unrealistic, and the prosecution would probably argue in those circumstances that it was very suspicious that someone had such a well scripted account of what was going on. So the discussions about the Asian grocer fall into that category. These are the kinds of arguments that were made to you. And he says he's not going to go through all of it. He says, I think the jury understands our point. She was never saying to anyone that she was certain about which suburb the shop was in, but the prosecution makes arguments to you like this. Erin didn't tell them what the packaging looked like until later. Collins says something that a detail that only came to her much later on is the argument. Yeah, something that only came to her much later on is the is the argument. He says, but McDermott, Foote, Muldoon, and Stewart, the first people that Erin spoke to on the topic, didn't ask her that question. The question they asked her was, do you still have the packaging? And Erin's answer was no. That's an example of answering the question that you're being asked. So he tells the jury to be careful about that conclusion. In each of those cases, you need to think about the question that Erin was being asked to assess the answer in the light of it. That was an example of her answering the question she was asked, not the question that the other 13 people were going to ask her the next day. Collins says, on our assessment of the evidence, Sally Ann Atkinson was the first person to ask that question, and Erin answered it. And there was back and forth and suggestions and options. And lo and behold, one of the small number of Asian grocers visited by Troy Shonking had packaging exactly like that, exactly like what she described. Clear plastic bag, repackaged and resealed, white printer label on it, handwriting on it, and sometimes the weight. A very specific memory, one that you could readily accept as true because it's exactly the type of packaging that Mr. Troy observed. And obviously, on all the evidence, she is saying, look, it is 3 months ago during the April school holidays. It was somewhere near the area I was staying. I can't remember exactly where. And the phone records demonstrate that that's where she was. They say Troy Shonknecht was never asked to check Glen Waverley. We know that people were told Glen Waverley by Erin early in the piece. He agreed, Dr. McDermott agreed with that in his evidence and his contemporaneous notes. We know that he spoke to Sally Ann Atkinson, who no doubt would have conveyed that information, but Sally Ann Atkinson was insistent she was never told Glenn Waverley, and that when she was told Glenn Waverley, this was an example of Erin changing her story. Collins says, well, it just isn't borne out by analysis of the evidence. She said that as soon as she understood it was Glenn Waverley, whatever the circumstances, she called Troy and asked him to follow up. They're saying here, this was Sally Ann Atkinson. She called Troy to ask her to be followed up as soon as she knew it was Glenn Waverley. And they say here, but Mr. Shonkneck was very clear. He says, I asked the department, and he says, I asked the department whether there were any other suburbs or stores if they wanted me to attend. And he was asked a question. I know he continues with his answer. This is Troy's words. And they effectively told you it's not going. Yes, no, they do ask him a question, and they effectively told you not to worry about going anywhere else. Troy replied, "That's correct." So he was asked this question in his evidence, and then his reply was, "That correct?" So yeah, I'll reread it. I asked the department whether there were any other suburbs or stores if they wanted me to attend. That's Troy. And then the question was, and they effectively told you not to worry about going anywhere else. And Troy's reply was, that's correct. And he says, so that was the end of the investigation. Colin continues now and says, yet another example in this trial, we submit to the jury of people who are honestly mistaken. And he says, that's Mr. Troy Shonkneck, says that he never was told Glenn Waverley, even though Sally Ann says she did tell him. Colin continues and says, now there is an example of people who are honestly mistaken. One of them is honestly mistaken. They say, Colin Mandy says, Glen Waverley, the suburb with the largest number of Asian grocers, was never checked, and Erin's account we submit to you is supported by several independent sources and nothing to do with her. The suggested presence of the second mushroom species, which is not death cap mushroom in the beef Wellington, and he says, uh, Dr. Lovelock, CCRs from April, bank records establishing that Erin pays in cash, similar packaging located by Mr. Troy. She was, we submit, telling the truth. And he says now there was cross-examination of Erin in relation to whether or not this conversation that she had with Simon, whether or not she asked about the health of others. And Collins says, we submit to you that you should be very careful about the conclusions that Dr. Rogers wants you to draw from that. Collins says, I'll tell you what she said in her address. And he's quoting the prosecution here. If she did love them as she claimed, one would expect her in that conversation to inquire about their welfare immediately. In those circumstances, but what did she do when Simon told her that Don and Gail were in hospital? This is Colin again. She immediately went on to. Oh no, sorry. Let me read this again. Colin says, "I'm going to quote the prosecution, and it's this: if she did love them as she claimed, one would expect her in that conversation to inquire after their welfare immediately. In those circumstances, but what did she do when Simon told her that Don and Gail were in hospital? She immediately went on to talk about her own symptoms and never asked a question about Don and Gail." That's from the Crown. That's from the prosecution. And Colin continues, that is the argument being made to you by the prosecution, not based in the evidence, because the evidence of the cross-examination of Erin was this. And he quotes, I suggest that you did not ask him at any point on being informed that Don and Gail were crook and in hospital. I suggest you did not ask how Don was at that point, correct or incorrect? And Erin's answer was, we discussed how Don and Gail were. That's how I found out they were in hospital. This was a conversation about them being unwell. And then they say, this is the cross exam. Do you say that this conversation about them being unwell occurred on the telephone with Simon on Sunday, the 30th of July? And Erin's answer was, yes, and I think you said that was his evidence too. And they say, his evidence was that he informed you that Don and Gail, Ian and Heather were crooked in hospital. And they say, we've been through that. That was not his evidence, not the whole of his evidence. And then when she was taken to the transcript of what Simon actually did say in this evidence, and quote, what did you tell her? This is the evidence about the phone call. Simon says that first part of his evidence, I told you that all four were crook and had been admitted to hospital. And he said, that's one question, one answer. The next question, did you ask how Erin was feeling? Simon replied, yes. And what did she say? Simon says, she said she had been having diarrhea herself and it was quite frequent. Collins says the implication the prosecution wants you to do is that he wants you to do, yeah, wants you to he's saying is that the implication is that he was talking to Don and Gail. She never asked how they were. She just went immediately on to talk about her own symptoms. Collins says that's not a fair conclusion to take from the evidence. He says the evidence is this is a phone call that goes for minutes. The reason why Simon is ringing is to tell her that Don and Gail are unwell. That's the conversation about it. Why, after the conversation, is she going to say to Simon, how are they? He just told her. And they said, there was a question. There was no evidence from Simon that there was a discussion between you and he at that point about Don and Gail being in hospital. And he says, I think the answer was, I'm sure what you just read out was that he claimed he told me they were unwell and in hospital. That's from Erin. And they say, Colin says, so be careful, members of the jury, about those kind of propositions without going back and thinking carefully about what the source material for them actually suggests. Colin says she was at pains, Erin was at pains to explain that the conversation had lasted minutes. That's what they were talking about. And the foundation for that whole argument is that she never asked how they were and went immediately on to talk about her own symptoms. And he says that's just not a fair conclusion from the evidence. Erin did ask how the lunch guests were, and that's it. Hold on, we got more, but that's it for that paragraph. They say here Simon Patterson's evidence when he gave evidence to the jury, he was asked three questions and he gave three answers on this particular topic. They were, what did you tell her? And Simon says, I told her that mum and dad, Ian and Heather, were all crook and they had been admitted to hospital. He was asked the second question, did you ask how Erin was feeling? Simon replied, yes. They asked him a third question, and what did she say? And Simon said, she said she'd been having some diarrhea herself and it was quite frequent. Colin continues and says, three questions and answers. That's it. The prosecution could have asked him all sorts of questions about that conversation, but it was three questions and answers. And apparently, those three question and answers permit the prosecution to say, what did she do when Simon told her that Don and Gail were in hospital? She immediately went on to talk about her own symptoms and never asked a question about Don and Gail. Collins says that is not a fair representation of the evidence and is not a fair representation because the prosecution could have asked all sorts of questions about a conversation that was much longer than three questions and answers. There you go. Sorry, it's a lot of talking tonight. A lot of talking tonight. Hey Penguin, how are you? Good to see you all. Hey Robbie T. Good to see you all. I know it's late, everyone. Good night, Robbie. Good night. Good night, guys. It's 11:12 already. Already? Already? All right. So he says it's not a fair representation because the prosecution could have asked all sorts of questions about a conversation that was much longer than three questions and answers. All right. All right. I want to talk to you a bit about the phones. So, phone A and phone B from Colin Mandy's closing statement. Yeah. All right. Yeah. Colin says, our submission to you, the jury, to address that conduct is to say that Erin Patterson had very different motivations for doing the things she did, other than those suggested by the prosecution, and these are the categories: pretending she's unwell, being reluctant to receive treatment, being reluctant to get her children treatment, disposal of the dehydrator, and the last of those topics is the phone evidence. And Collins says, now this is the prosecution's answer for the deficiencies in their case and the deficiencies in their evidence, and they want you to use the absence of evidence to fill the gaps. He says the gaps are, or the propositions are, that Erin was familiar with iNaturalist and that she saw a post by Dr. Mackenzie, that she saw the post by Dr. Tom May to explain the absence of records we know would be generated if those things had actually occurred. He says, but why would she go to all the effort of setting up phone B as a dummy phone to give to investigators? Why would she? Why would she go to that effort? Because that was at the time when she had no idea there was going to be a search warrant executed on the 5th of August. Collins says, we're talking about August the 3rd. She had no notice that police were coming to search her house and interview her on that day. As soon as police looked at it, they would have found out, and he's talking about phone B, they would have found out that it had nothing on it, that it had been factory reset. Extremely simple checks of the phone records, hospital admission records, bank records, and on it goes would reveal simply and very quickly that she had been using a different number. Collins says, now if she knew that she had committed a wait, now, if she knew that she had committed murder, that is, believed herself responsible for it, and was anticipating that police would come and search her home and seize her phone, then she would have done something far easier to avoid any chance of police finding the evidence. If the intent was to conceal the contents of phone A, why wouldn't she just factory reset it, and hand it over to police? If the intent was to conceal the existence of phone A, why continue using it? Better yet, why not get rid of it at a much earlier stage? She had the opportunity to dispose of it after she got home from the hospital. She says, what? Collins says, why not take it to the tip? If she had planned the cold, calculated murders that the Crown says she committed, deliberate murders that the Crown says she's planning at least from April 28th, and had been and had incriminating searches on her phone, this would have been part of the plan. Surely, it would have been destroying the phone. It would have been destroyed. The phone. The phone would have been long gone by that time. The police knocked on the door, so he's saying the phone would have been long gone by the time police got to her home. And he says, or it would have been factory reset. It could have been done at any time, before the lunch, after the lunch, when she was in hospital, and that's exactly what she would have done. You know that because that's exactly what she did do with phone B on 3 occasions in early August. The fact that she continued to use phone A after the lunch is far more consistent with her account than the convoluted prosecution theory about a dummy phone. It is an important theory for the prosecution because it provides them with an explanation for evidence that doesn't exist. And Collins says, you will remember the CCR records that we took, that they showed the jury on the 4th of August, that demonstrate that Erin was changing her phone number in the days before and communicating with Centrelink, Australia Post, MyGov, etc., because she was in the process of changing her phone number. And you will remember that on that day, the 4th of August, she told Katrina Cripps that this is what she was going to do, and that is all consistent with her planning on changing her phone number. Dr. Rogers referred to the agreed facts in her address and said that there were three possible explanations. And he says, you've got the facts, uh, and then, yeah, you've got the facts. She said all three involved a person actively handling the phone. Collins says, but if you look at the exhibit or the evidence, I'm not suggesting you do that at the moment. He's not telling the jury to do it right now. And he says, but I'll read it to you. This could be due to, and the handset being damaged in such a way that would disrupt power to the handset or disrupt the handset's connection to the network. Collins says that doesn't mean someone has to actively handle it. He says there is no evidence that the handset being damaged in such a way that would disrupt power of the handset or disrupt the handset connection to the network requires human input. Collins says, remember, this agreed fact is about when the SIM card for the the number is 7 redacted. The number 7 SIM card stops connecting with the network, so it can still be in the phone, but the phone's damage stops it from connecting to the network. Phone A was damaged, and that's the reason why Erin stopped using it. And Erin's account is consistent with the informant's evidence about the search warrant. His evidence was he's tasked with monitoring her. She was accompanied by a police member at all times except for a period when she was allowed to make a phone call to a lawyer at 2 p.m. That's in the records. You can see the phone call. He was also firm about the time himself. He had written it down in his notes, and we know it's accurate. He was asked questions about it in cross examination. He confirmed that she was allowed to retain her phone, that is, phone B, but she was accompanied at all times by a police member from the homicide squad. And the instructions that were given to her were you can't use your phone other than making arrangements for your children or speaking to a lawyer. Collins says, now, could she could now, she could not have somehow concealed and covertly removed the SIM card from her phone while being under constant observation of experienced homicide squad detectives who are in the middle of executing a search warrant looking for electronic devices. It's not possible. The only possible opportunity that she could have had that done was at 2 p.m., and that must mean that phone A had been hidden in the same room that the police happened to take her to in order to communicate with lawyers. Collins says that's quite a feat, but it doesn't account for the phone records themselves because the service had lost connection with the network by 1:45 p.m. So that's 15 minutes before she had any opportunity to access the phone in that way. Erin's account we submit to you is the one that fits the evidence the best. If she had successfully hidden phone A from investigators, why did she wait until 1:45 a.m. the next day to put the SIM card into a different phone? Wouldn't she have just returned home and simply started using phone A again? There's no evidence that phone A was ever used again, consistent with it being damaged. Again, we say the evidence is more consistent with Erin's account. She couldn't use it because it was damaged. She got back home at 7 to 8 o'clock, between 7 and 8 o'clock that night. She put the SIM card into the Nokia because it took her some time to work out what had been left in the house by police. The stupid thing she did was factory reset phone B a couple of times, entirely consistent with someone who was panicked for no good reason at all, because there was nothing to be achieved by factory resetting phone B. Dr. Rogers submitted to you that police searched the house seized every device they saw. Their goal was to get every electronic device they could. They took everything they found. So he says, so much might be true, but you know that they missed electronic devices in the first search on the 5th of August, items that were still in the accused home and were later seized by police on the 2nd of November. They weren't things that were concealed, they were just missed. Dr. Rogers suggested that homicide squad detectives wouldn't make a mistake like this, but we know that they made other mistakes like not disconnecting phone B from the network. You will recall that we asked questions of Luke Farrell and the informant about the devices that they may have missed in the first search of the house. That is, electronic items in plain view that were not seized by police, and the exhibits in relation. He's going to talk about it to the jury. He says, "I'm not going to take you to them right now, but police officer Luke Farrell was asked questions about an exhibit." He says, if we go back to the first photograph, if you've got that, he's asking if the jury has it, and it says no record of anything else being seized from this part of the house, and they say that's right, that's correct. Item sitting on the windowsill there, black item. You didn't seize it because there's no record of it. Farrell replies that's correct. They ask him, you don't recall having seen it? He says, I don't recall whether I saw it or not. And they say, and there is an electronic item on the ottoman. And Colin says, I asked him some questions about that. Detective Eppingstall was asked questions about it as well, and it was suggested to him that the item on the windowsill was in fact phone A sitting on the windowsill, and his answer was, no, I've got no idea. He says, I don't think that's consistent with a phone, but it is a matter for the jury, I'd say. If it was a phone, I think we would have found it. And that's what Detective Eppingstall said in his evidence. Collins says we also took him to photos from the search on the 5th and then the 2nd of November. And he says, the jury, you will remember that the evidence about two black items sitting on the shelves in the study, and he agreed that they returned to the house to seize a number of items on the 2nd of November, and there were electronic devices that they seized that day, but he wasn't sure whether or not they had seen them on the first day. And I suppose that makes sense because if they had, they would have seized them. And he's quoted here saying, our goal was to get every electronic device we could, so we took everything that we found. And then Colin says, then we showed him two laptops, clearly electronic devices, and he agreed that those items on the shelves have a similarity to a laptop not seized by police. Two laptops and another third laptop. He was asked these questions in re exam. Do you have any knowledge as to why those three laptops were not seized on the 5th of August? And his answer was, I would assume they weren't found. Collins says we suggested that there were other electronic items that were visible and not seized, like, for instance, a USB storage device in the pantry. And his response to those questions was, I'm. He says, although I was the lead investigator, it wasn't my role on that day. And what he's saying is to seize items or find items. He was the lead investigator. They say, now we suggested to him that the item sitting on the shelf in the photo, he says, a little black item. And they say, can you see a small black rectangular case? And he says, I can see two black rectangular items there. And it was suggested that that was the same object that had been sitting on the windowsill in the first search. And he replied, I wouldn't be able to say. So there you go. So they're trying to say that items were left in plain view that police did not seize, and that's what some of these questions are related to Eppingstall and the other police officer that in cross examination. So, all right. Thanks, Sean. I appreciate it. Sorry, I know it's a lot of talking today, guys, but this is the last one. This is the last bit that we'll hear from either of them, the prosecution or the defense. That's it. Like I said, after this it is up to the judge and then the jury. This is it. Okay, and they say here, we want to say this to you about concluding this topic in response to the prosecution's incriminating conduct or incriminating conduct allegations that they make. These are the propositions. There is no rule of human behavior. That behavior that you engage in or that Erin engaged in after the lunch is only engaged in if you believe you're guilty of murder. And they say, His Honor will direct you as a matter of law that the law recognizes that there might be all sorts of reasons why a person engages in conduct that to everyone else in the outside world may make them look guilty. There are all sorts of reasons why an innocent person can engage in that type of conduct, like dumping the dehydrator and lying. And he says, now you have those reasons. He says, Erin got into the witness box and told you she did those things because she panicked. And when confronted with the terrible realization that her actions had caused the illness of people that she loved, it didn't excuse what she did, not making an excuse about it. But you can't jump from there to what the Crown wants you to conclude from those items of evidence. And Colomandy says, he says he wants to take the jury to a summary about Dr. Sorrell's evidence. And he says, our overarching submission is this, that you must be especially careful where there is insufficient or incomplete evidence. And you understand that Dr. Sorrell's opinions were heavily qualified, usually in the terms of consistent with a possible visit. Those kind of expressions and the complexity of that evidence is skipped over. In our submission, when the prosecution addressed you, the nuances, the important limitations have been ignored, and you have to approach that evidence cautiously and consider the alternatives that Dr. Sorrell agrees are open on the evidence and can't be excluded. The Crown attempted to rely on his limited evidence as evidence of a possible opportunity on those days to go to those locations, so possible opportunity, and combine it with the evidence of the post from iNaturalist, where there is no evidence that Erin ever saw them, and that's an attempt to give you an impression of coherence or relationship between two things, one a possibility and one where there isn't any evidence, events that may have never happened, each of them. And he says, Dr. Sorrell's analysis, he told you, didn't take into account the travel time to get to those locations. The prosecution, in their closing, referred to general travel times between Leongatha, Locke, Leongatha, and Outram, and they ignored the informant's evidence in cross-examination, which were door-to-door times about the travel times between the accused house and those locations, which in the defense's submission to the jury is really the only relevant travel time. And he says here, so the prosecution said Locke was 23 minutes driving time from Leongatha, but the informant agreed that door to door it could be up to 29 minutes, so that adds an extra 12 minutes to the round trip. The prosecution said that Outram was a 15 minutes driving time from Leongatha, but the informant agreed door to door it's up to 24 minutes, and that depends on the route you take. So that's an 18-minute difference between those two, the round trip, and it is important that you will take into account because it goes to the possibility of those brief windows if they could be suggested that they were windows at all. He says here, you could never exclude we submit to the jury. And he says here, if they could be suggested that they were windows at all, you could never exclude we submit to you. So firstly, on the 28th of April, Dr. Sorrell says that that's a possible visit, and he can't say anything more than that. On the 22nd of May, both occasions, you could never exclude that other possibilities are open on the evidence, and he agreed with some of that. Uh, he agreed with some of the cross examination about what those other possibilities might be. So even if you thought that the records did suggest that Erin's phone was in the lock area, for instance, on the days relied upon by the prosecution, there's no evidence that she was there to collect death cap mushrooms. And it is not for us to prove that she went there for some other reason. That's a reversal of the onus of proof. The prosecution has to prove the case. The prosecution has to prove she went there, and she went there to pick death cap mushrooms. And you could never be satisfied of that on this evidence. And they're saying here, she was asked in cross examination, and the question was, you never had a legitimate reason to be in lock, correct or incorrect? And Erin's answer was incorrect. And then Colin continues and says, then you might think that someone who lives in these areas has every legitimate reason or many legitimate reasons to be in a neighboring town. In circumstances, you might not remember the reason why you went there on that particular day if you did. So take those things into account in relation to Dr. Sorrell's evidence, especially especially his very frank confession about what the limitations of his evidence. Yeah. Okay. Finally, the prosecution theory that Erin thought knowingly that these people would all become seriously unwell, that would all be passed off as some kind of strange case of gastro. And he says where one died, where case of gastro where, yeah, yeah, sorry. Finally, the prosecution theory that Erin thought knowing that these people would all become seriously unwell, that it could all be passed off as some kind of case of gastro. And he says, wherever one died except her, I think he means like three died, the three people died, one didn't, except her. And he says that she pushed ahead regardless, never realizing that the spotlight would be on her. We submit to you that that's illogical. Now, Dr. Rogers concluded her address by providing you with an analogy about how you find facts in a criminal case, and she said to you, it was like a jigsaw puzzle. You get the pieces, see where they fit. The prosecution relies on each piece of evidence to form the case as a whole. We often tell juries that it helps to think of a case like this as a jigsaw puzzle, etc. Collins says that the defense's submission to the jury is that is a seductive analogy, but it's not a very useful one, and it's misleading when it's applied to criminal trials, because what happens when you buy a jigsaw puzzle is that you've got the picture on the box. You are trying to get all of the pieces to fit the picture on the box. You know what the final image should look like because it's on the box. In a trial, assuming you know the picture is guilt, and then trying to make the evidence fit that picture is working backwards. And perhaps that's why you are encouraged to think about it in that way, because that's our submission about the prosecution, about what the prosecution has done, taken things using the benefit of hindsight to create a picture. Jigsaw pieces only. He said the theory is that jigsaw pieces only fit one way, but evidence can be interpreted in multiple ways, so the analogy breaks down on that level. Evidence often has multiple reasonable interpretations, as this evidence does. A piece of evidence that the prosecution claims fits their theory might fit equally well with an innocent explanation. And he says, this is another proposition. You can't force jigsaw puzzle pieces together. When puzzle pieces don't fit naturally, when you are making the picture, you've got the wrong picture, the wrong piece in the wrong spot. It is not fitting naturally into that gap. But prosecutors can, as we've seen in our learned friend's address, force the evidence to fit their theory in a way that does not apply to jigsaw puzzle pieces, stretching interpretations, ignoring alternate explanations because they don't align perfectly with the narrative. So, missing puzzle pieces in a jigsaw puzzle can make the picture incomplete. but missing evidence is much more significant, and we have been through it in this address. All of those items, especially of expert evidence, which are missing, which the prosecution relies on to make the puzzle complete. You can't fit it in the gaps, fill in the gaps with speculation, guesswork, or theories. You can only act on the evidence because the jury is the judges. The standard is the standard of proof is beyond reasonable doubt, not a close enough recreational. he says he says not close enough. So the real question isn't whether pieces can be made to fit, but whether the prosecution has proven guilt beyond a reasonable doubt based on the evidence as it actually exists, and not that they wish it existed. And he says, in conclusion to his final statement, we say to you that the prosecution's argument is this: if you pick and choose, if you rely on misleading impressions, if you assume witnesses can never be honest but mistaken, if you use hindsight to reconstruct events to suit a theory, if you work backwards without any expert evidence to establish the fundamental propositions that you rely on, then you can manufacture a picture. And he says that's what's happened here. They started at the end and worked backwards, found death cap mushrooms in the meals, they investigated. Erin wasn't as sick as others. She got rid of the dehydrator, and she was telling a bunch of lies, and they work backwards with the benefit of hindsight. And he says, assuming she is guilty from the start, then picking the pieces of evidence that fit that theory. Colin says, we have posed some questions to you. And he says, about the likelihoods. So does an absence of motive make it more likely that this was an accident? What's more likely, that she wanted to kill everyone, or she wanted to reconnect with everyone for the sake of her children? What's more likely? Uh, he says, she fed the children the meat with the mushrooms scraped off. She threw out the rest. She didn't know the meal had poison on it. Those kind of questions. Colin continues and says, now you need to be careful about thinking about likelihoods. He says he knows it's his fault because I asked the questions, but that's not the way a criminal trial works. When it comes to the standard of proof in a criminal trial, in the same way it is with Erin's evidence, this is not a balancing exercise. He says, I've asked you those questions about likelihoods to illustrate how convoluted the prosecution's theories are, but you don't decide the case on what's more likely than not. You can't weigh the prosecution case against the defense case and ask yourself whose case is better, because that would be wrong. The standard of proof in criminal trials is beyond reasonable doubt, and the prosecution has to prove all of the elements of the offense to that standard. The burden of proof, that's why it's called the burden of proof, because it's something they carry, they bear it. They have to prove the elements of the offenses, and they have to call the evidence to establish the elements of the offense. So those are the principles of a criminal trial, the golden rules, he says, if you like, which protects all of us. And you might be thinking to yourself, well, I'm never going to be on trial for a criminal offense. But Colomendi says, you never know. If there is an honest and mistaken witness out there who said you did something wrong, you might well find yourself on trial. So these principles protect all of us. They protect all of you. They protect his honor. They protect everyone here. They protect us from being wrongfully convicted. Collins says, a jury can't say, oh, well, she's probably guilty, so that will do. A jury can't say, oh, well, this is all a little bit suspicious. This is all a little bit dodgy. A jury can't say she lied about her lump on her elbow. She lied about cancer. And they say she said terrible things about her in-laws in a Facebook chat. She shouldn't have done those things. They're wrong. They're terrible. They're morally reprehensible. She behaved badly. We would never do those things, and therefore we're going to convict her. That's not proof beyond a reasonable doubt. That's not an intellectual, clinical, rational reasoning process. And he says, they, the prosecution, are the state. They bring the allegations and they have to prove it. So that's our criminal justice system, and that is the way it should work. A trial like this sometimes seems like a competition, one side against another, like we're competing against each other like a boxing match or a football match or netball or whatever it is. The truth is, it is more like high jump, and he says this is important. Only the prosecution has to get over the bar. Defense doesn't have to do anything. Defense doesn't have to jump any bar. Erin Patterson doesn't have to jump any bar at all. The prosecution have to clear the bar, and that's the highest bar known to law, and that's where you are now. You are at innocent with Erin Patterson. That's your starting point. The starting point is innocence. She is presumed innocent of all these charges. She doesn't have to prove her innocence to you because she is innocent. And it is for the prosecution to disprove her account of accidental poisoning beyond reasonable doubt before you can move from that position, before you can find her guilty of anything. And he says, when you go out to deliberate next week, you have to decide how far up that scale this evidence can take you. And he says, the evidence, only the evidence, not prejudice, not sympathy, rumor, speculation, misleading impressions. He said, and he says, honest and mistaken witnesses. So, in his conclusion, the way of thinking about this in relation to deliberateness, and he says, was the poisoning deliberate? If you think that it's possible that Erin poisoned the meal, you must find her not guilty. If you think that Erin deliberately poisoned the meal, you must find her not guilty. If you think that maybe Erin deliberately poisoned the meal, you must find her not guilty. If you think that she probably deliberately poisoned the meal, you must find her not guilty. If you think it's possible that she intended to kill or cause really serious injury to Don, Gail, or Heather, you must find her not guilty. If you think maybe she intended those things, then you must find her not guilty. If you think probably she intended those things, you must find her not guilty. If you think it's possible Erin intended uh, to kill Ian, and you have to find her not guilty. Maybe she intended to kill Ian, not guilty. Probably not guilty. If you think at the end of your deliberations, taking into account the arguments we've uh, made that it is a reasonable possibility that this was an accident, a reasonable possibility, you must find her not guilty. And if you think it is a reasonable possibility that her evidence was true, you must find her not guilty. And our submission to you is that the prosecution can't get over that high bar of beyond reasonable doubt. And when you consider the actual evidence, and not when you consider uh, he says, when you consider the actual evidence and not when you consider the actual evidence and consider it properly, methodically, analytically, your verdicts on those charges should be not guilty. And he thanks everyone for their attention and thanks the members of the jury. So that was his closing address. And you hear it there what his 4 points were. And his 4 points were about that scale where it's innocent, and then the prosecution have to drag them to the guilty because she is innocent at the start, is what he's saying in his address. And you hear here about here, where's the 4 points that he had? Yeah, he talks about like, yeah, honest but mistaken witnesses. Uh, So I'm just trying to find that little bit that he was talking about. Yeah, let me go all the way up here. Let me see if I can find his original thing for it. But that's the end of it, everyone. That's the end of it. I know it was a lot of reading. How long have I been reading for? Like an hour and 20 minutes or something? I wanted to bring you as much as I could of his final statement. Now, I can't read all of it because it would take me 9 years to do it, but I wanted to bring the bits that I wanted to report to you. Here. All right. I can't find the exact quote, but I read it out before. But yeah, you can hear what he laid out for the jury in that final address. Hey, yeah, thanks to everyone supporting the channel. I appreciate it. It's very kind of you all, including Aussie Tad. Thank you. That will buy many, many pizzas. I appreciate it. Good to see you all, guys. So that's just about it. That's it. We're on a 4-day long weekend now. And Sean, Sean, that's very kind. Thank you very much, buddy. I appreciate it. We're on a bit of a long weekend now. So, what are we going to do tomorrow? Well, I'm hoping that we'll be able to do some normal true crime from tomorrow. That's what I'm hoping. I have no idea. I really don't know, Zen. I have no idea. I think each case is different. Um, you know, some short cases that only go for a week sometimes have a really long deliberation. Sometimes ones that go for a long time have a short deliberation. Sometimes they're the reverse, where you get a trial that only goes for a week and they have a short deliberation, and then you have ones that go for a long time that have a long deliberation. So it's hard to know. It's up to the jury, and they will. There's no time limit in Australia for how long a jury can deliberate for. So if they need 2 months, they could have 2 months if they wanted to. There is no time limit. So it's however long it takes them to get to a verdict. So it's up to them. It's in their hands as the jury that are supposed to act like judges and judge the evidence and find the truth. It is up to those people of the jury. So hey, good to see you. Or hey, Woman of Steel, thank you very much. Thank you for that. Before I'll just say that. Betty C, hey Betty C, how are you? Laura T's here. Warner Steel, everyone's here. Good to see you. Hey Texas, good to have you guys. Hey Factual Lie, good to see you all. I hope you're all able to um follow my reading tonight, and I hope it was better than last night. Last night I looked so tired on the live stream. I watched it back this morning and I looked terrible. It looked awful. I looked like I was falling asleep at the microphone, so I'm sorry about that. I hope I look a bit more awake tonight and a bit more lively this evening. Good to see you all. How are you going? I did, Zen. I did hear that. Yep. Hey, Bizarre Life. How are you, my friend? Good to see you. Good to have you. Hey, Laura T. Yeah, I hope it just gave you an inside look into that rest of that final statement by Colin Mandy, especially that ending, that which was his final words to the jury. That's it. That's it. That's his final thing. By the way, we do have a new chair coming, so you won't get this anymore. The squeakiness. No more squeakiness. Okay. All right. I think that's it until tomorrow. What are we going to do tomorrow? I think you might get a late show at midnight. At midnight Eastern tomorrow, we're probably going to be able to do a late show on a Thursday night. I don't think we've done one of those in about 2 months, 3 months. So because we normally have court on a Friday, but we don't at the moment. Not this week. So what happens now? Well, I told you at the start of the show, but we're done until next week when the judge will read out his charge to the jury. And then after that, the jury will be sent away to deliberate on everything they've heard over the past 8 weeks. And when they're ready, I will tell you what their decision is. When I finally get told, when I hear that evidence in court, I will be on this live stream as quick as I can, and I will be live uh giving you that verdict. I will be probably the first person on YouTube that will be live telling you what happened and what we heard in court that day. So, okay. All right. Well, I hope you have a nana nap. All right. I am going to get out of here. It has been a long day today, and you can see I still look a little tired. I love you all. Have a great day out there. Get ready for a late show tomorrow. And we should have a new chair soon so it stops doing that squeaky noise. We will have a new chair. I've ordered one. I'm just waiting for it to get in. You haven't heard it? Oh, I'm glad you guys can't hear it, but it's driving me mental. So I'll show you here. So that's the new chair I bought. Um, for here. This is the new chair you'll see when I finally get it, and you'll be looks nice and comfortable. So it'll be nice and comfy. Maybe a little more comfortable than this one. This one doesn't have any padding left. You can feel the metal in it. I've had it for about 12 years. So thank you, Quiet Observer. Good night. Thank you, Sean, for your donation. I appreciate it. Thank you to Aussie Tad. I appreciate it. Jay, thank you for gifting that membership. Sean, and Sean again, thank you. Yeah, hit that like button. And if you want to be one of the first people in the world to hear what the verdict is in this particular trial, you should be hitting that subscribe button because that's the only way you'll get a notification on verdict day. On verdict day, if you want to be one of the first people in the world to hear that verdict and what has happened, you need to click that subscribe button so you will get a notification when that live stream goes live. And I promise you, I will be racing to outside so I can give you a verdict, and you'll be some of the first in the world to hear it from someone sitting in the courtroom. So I love you all. Yeah, please subscribe to the channel. It would help out a lot. I love you all. I'm going to enjoy my long weekend. And yeah, thank you to the people who support this channel. There's no way we could have done this trial without all those people. It's been a gargantuan effort to do this. What will probably end up being 9 or 10 weeks by the end of this. It'll either be 9 or 10 week trial. a two, an almost 2.5 month trial. It has been a very long process, and that's not including the 2 years before that we spent following all of this. So it's been a hell of an endeavor for this channel. Yeah, I will get some rest. Thank you. All right. Good night, everyone. Love you all. See you later. Bye.